The sources list some relevant and irrelevant ones, figure 4D.
Right. Relevant factors courts look at include the preference of the child, but only if the child is mature enough to express a reasonable preference. More weight given as the child gets older. Keeping siblings together is usually preferred if possible. Any history of domestic violence by either parent is extremely relevant and heavily weighted.
What factors are generally considered irrelevant?
The source lists the race or religion of the parents. Also, the parent's sexual conduct or lifestyle is generally considered irrelevant unless, and this is the crucial caveat, it's shown to have a direct negative impact on the child.
So, a parent's lifestyle choice itself isn't grounds to deny custody unless it's actually harming the child.
That's the standard outlined here, yes. The focus has to be on the impact on the child. The court also considers who has been the child's primary caretaker, the parent handling most of the day-to-day needs, and importantly, the sources stress there's no automatic preference for the mother anymore, no maternal presumption. It's gender neutral.
What happens when the fight is between a parent and a third party, like a grandparent who wants custody?
There's a strong legal presumption in favor of the parent. Parents have a fundamental right to raise their children. A third party can only get custody over a parent if they prove either, 1, the parent is unfit due to abuse, neglect, abandonment, etc., or 2, awarding custody to the parent would actually be detrimental to the child's well-being. It's a high legal hurdle for a non-parent to overcome against a fit parent.
It's significant protection for parental rights there. Okay, let's talk about visitation and parenting time for the parent who doesn't have primary physical custody.
The non-custodial parent generally has a right to reasonable visitation or parenting time. A critical rule, emphasized again by the sources, visitation can only be denied entirely if the court finds that visitation would seriously endanger the child's physical, mental, or emotional health.
That sounds like a very high bar for denying all contact.
It is, and repeating the point from support, failure to pay child support is not a valid reason to deny visitation. They are separate issues.
Can visitation be restricted, even if not denied completely?
Yes. Courts can impose restrictions if needed for the child's safety or well-being. Things like requiring visits to be supervised or prohibiting overnight stays. Regarding a parent's lifestyle, like cohabitation or sexual relationships, restrictions are only imposed if there's proof it's adversely affecting the child. And the source explicitly states that having HIV or AIDS is not a basis for denying visitation.
What about third parties seeking visitation? Grandparents, step-parents?
This is constitutionally sensitive. Fit parents have a fundamental right to make decisions about their child's upbringing, including who they see. Therefore, a fit parent's decision regarding third-party visitation must be given special weight by the court.
Meaning the court should generally defer to the parent's wishes.
Pretty much. A court can't just override a fit parent's decision to deny grandparent visitation simply because the judge thinks visitation would be nice. There usually needs to be a showing of harm to the child if visitation is denied, or some other exceptional circumstance to overcome the parent's decision.
The source mentions specific categories of third parties, figure 4E.
Yes. Step-parent visitation is usually limited to those who truly acted in loco parentis, like a parent, before the divorce. Non-biological co-parents might seek rights depending on the state. Grandparent rights are subject to that special weight rule often. Statutes allowing grandparent visitation have been challenged or narrowed based on the fit parent's rights. An unwed biological father has constitutional rights to seek visitation if he has stepped up and demonstrated a commitment to parenting responsibilities. His involvement matters.
What if one parent interferes with the other's court-ordered visitation? What can be done?
Courts have remedies. They might order compensatory visitation, make up time. They can hold the interfering parent in contempt of court. In serious ongoing cases, it could even be a factor in considering a change of custody.
How are custody orders enforced generally if one parent isn't following the rules?
There are various sanctions, figure 4F. Besides contempt, which could mean fines or jail, courts might order compensatory visitation, make the violating parent pay the other's attorney's fees and court costs. The source mentions tort damages might even be possible for wrongfully keeping a child. Habeas corpus isn't the usual tool for custody disputes anymore. Injunctions are more common. For interstate enforcement under UCCJEA, as we said, register the order and the new state can enforce it using its powers. But again, the new state generally can't modify the order unless the original state gives up jurisdiction and the new state has grounds to take it, with proper notice to everyone.
Okay, similar enforcement principles to support. What about modification of custody or visitation orders? Can they be changed?
Yes, they are generally modifiable. The standard in most states is showing a substantial and continuing change in circumstances since the last order was made, such that the current order is no longer in the child's best interests.
Does violating the visitation order automatically lead to a change in custody?
Not automatically, but it's definitely a factor the court will consider when deciding if modification is warranted. Consistent interference with the other parent's relationship can weigh heavily against the interfering parent.
Relocation. One parent wanting to move away with a child often triggers modification requests. How is that handled? It seems very contentious.
Extremely contentious and common. A parent usually needs court permission or the other parent's consent to relocate significantly. They generally need to show a legitimate and reasonable purpose for the move. Some states give the custodial parent a presumptive right to relocate if it won't harm the child's welfare. Courts look at a long list of factors. Figure 4G. The quality of the child's relationship with both parents, the child's age, needs, and preference, if mature, how feasible it is to maintain the child's relationship with the non-relocating parent after the move, the parent's history of cooperating or not, whether the move will genuinely improve the quality of life for the child and relocating parent, the reasons for the move and the reasons against it, and all other relevant best interests factors.
That's a huge balancing act for the court. What about the custodial parent cohabiting with a new partner? Is that grounds for modification?
Sometimes raised, but usually requires more. Some states might see it as a change in circumstances, but generally the party seeking modification still needs to show that the cohabitation is having an adverse effect on the child. Just living with someone isn't typically enough on its own to change custody.
Okay, we've covered a massive amount. Forming marriage, ending it, property, support, custody, jurisdiction, enforcement, modification. What about marital agreements? Can couples make their own rules?
Yes, couples can enter into agreements to define financial rights and responsibilities, either before or during marriage or upon separation. The sources discuss a few types.
Like prenups.
Exactly. Premarital agreements, also called prenuptial or antenuptial agreements, these are made before marriage. The marriage itself is considered valid consideration for the contract. Many states require them to explicitly say they apply in case of divorce.
Can a prenup decide everything? Child custody, support.
No, and this is crucial. Clauses in premarital agreements dealing with child custody or child support are generally unenforceable. Courts retain the power to decide custody based on the child's best interests and child support based on guidelines and the child's needs, regardless of what the parents agreed to beforehand. Parents can't contract away the child's rights or the court's duty.
That's a critical limitation. What about choosing which state's law applies?
The source says most states will apply the law of the state that has the most significant relationship to the agreement and the subsequent marriage.
Okay, so premarital agreements cover things before marriage. What about agreements made when separating?
Those are separation agreements. Couples make these when they are separating or planning to divorce. They can cover everything: property division, spousal support, child support, custody, visitation. Usually these agreements get merged into the final divorce decree, meaning they become part of the court order and are enforced that way. If not merged, they're enforced just like a regular contract.
And the rule about child provisions.
Same as prenups. Any parts of a separation agreement dealing with child custody or child support can still be modified by the court later if it's necessary for the child's best interests.
And property settlement agreements.
These specifically focus on settling the economic issues, property, debts, usually before the final divorce decree is entered. They are generally enforceable as long as they weren't obtained through fraud and aren't unconscionable, grossly unfair.
How do courts determine if these agreements, premarital, separation, property settlement, are actually valid and enforceable? What are the requirements? Figure 5A.
Generally, the agreement must be in writing and signed by the party you're trying to enforce it against. To be enforceable, it usually needs to meet several tests at the time it was signed. There must have been full financial disclosure between the parties, the terms must have been fair and reasonable when made, and entry into the agreement must have been voluntary. No fraud or duress.
So, writing, signed, disclosure, fairness, voluntary. What about the Uniform Premarital Agreement Act, UPA? The source mentions that.
Yes, about half the states have adopted the UPAA. It shifts the burden of proof. Under the UPAA, the agreement is presumed valid, and the person trying to avoid enforcement has to prove either: 1, they signed it involuntarily, or RR. 2, the agreement was unconscionable when executed, AD. They also meet 2 other conditions. They did not receive or waive fair disclosure of the other's finances, and they didn't have, and couldn't reasonably have had, adequate knowledge of the other's assets and debts.
So the UPA makes it a bit harder to overturn a prenup.
It can, yes, by putting the burden clearly on the challenger.
What if the marriage itself is later annulled, found to be void? Is the prenup still good?
The source says a premarital contract is enforceable after an annulment only if doing so avoids an inequitable result. It's looked at through a fairness lens.
And there's a sort of safety net mentioned. Impoverished spouse.
Yes. Even if an agreement seems valid on its face, a court might still set it aside if enforcing it would leave one spouse so poor that they'd likely become dependent on public assistance, like welfare. This ties back to the idea that agreements can't be drastically unfair or unconscionable in their outcome.
Can these agreements prevent future modifications of support?
This is a key distinction. Agreements can include provisions that prevent future modification of property division and even spousal support. Parties can agree that alimony will be non-modifiable.
But not child support.
Correct. Provisions in any marital agreement that try to prevent future modification of child support are unenforceable. Again, child support is the child's right, and the court always retains the power to modify it based on the child's best interests and changed circumstances. Parents cannot permanently bargain that away.
That distinction between modifiability of spousal versus child support in agreements is really important to remember. Okay, we've covered the core relationship issues. The final section in the source deals with the relationship between the family and the state areas where the state gets directly involved, like adoption, domestic violence, and kids' rights.
Right. Let's start with adoption. This is the legal process that creates a parent-child relationship between people not biologically related that way.
How does it usually happen?
Often through voluntary termination of the biological parent's rights. They consent to give up their legal rights so the child can be adopted. The source notes specific rules regarding unwed fathers' consent if they haven't registered with the state paternity registry or demonstrated a commitment to parenting. Their consent might be implicitly waived or they might lose the right to object. Also, an interesting detail, a child being adopted, if they're over a certain age, the source says usually 14, typically must also consent to their own adoption.
So teenagers have a say. What if the biological parents don't consent?
Then the only way to proceed is through involuntary termination of their parental rights, which requires a court order. This usually happens in severe cases handled by Child Protective Services, abuse, neglect, dependency, or sometimes if a parent is found to be unreasonably withholding consent to an adoption that is in the child's best interest. The grounds listed include things like abandonment, abuse of a sibling, having rights terminated over a sibling previously, severe neglect, chronic failure to support, or inflicting serious harm.
Serious grounds. What are the legal effects once an adoption is final?
It completely reorders the legal relationships. The adoptive parents get all the rights and responsibilities of biological parents. The adopted child gets all the rights and responsibilities of a biological child in that family, including inheritance rights from the adoptive parents. Contact with biological family. The source says most states allow no visitation with biological parents after adoption. Some might allow continued contact with others, like step-parents the child was close to, if it serves the child's best interests. Adoptions are generally final and hard to undo, barring exceptional circumstances like fraud or undisclosed major health issues.
The source also mentions adoption alternatives under the Uniform Parentage Act, UPA.
Yes, the UPA, adopted in some states, provides modern rules for establishing parentage. For assisted reproduction, it generally says the woman giving birth is the mother, unless there's a valid surrogacy agreement, and her husband is the father if he consented. It also addresses gestational agreements, surrogacy. These agreements, where a surrogate carries a child for intended parents, usually require court approval involving all parties. There's a presumption that a child born within 300 days of assisted reproduction resulted from that process.
Okay, updating parentage rules. What about domestic violence? How does the law intervene there?
Every state has civil domestic violence statutes. These laws define who is covered, often broadly, including current or former partners, household members, family members. The definition of violence usually requires a pattern, but the source notes a single severe episode might be enough. It generally involves physical abuse, though definitions are expanding.
How does someone get protection?
The process usually starts with the victim getting an ex parte protective order. Ex parte means the court issues it quickly based just on the victim's side, without prior notice to the alleged abuser, because of the immediate danger. This order is temporary.
Then what?
Then, the alleged abuser gets notice, and there's a full hearing where both sides present evidence. After the hearing, the court can issue a longer-term protective order, like an injunction. These orders typically prohibit the abuser from contacting or harming the victim and can also deal with temporary issues like who stays in the house, temporary custody, and support. Violating a protective order is a criminal offense.
So immediate protection followed by a full court process. Lastly, the rights and obligations of children themselves. Parental authority isn't absolute.
Correct. The state can intervene to protect children. As we discussed, courts can terminate parental rights entirely if it's in the child's best interests, based on those serious grounds like abandonment, neglect, abuse. Children also gain some rights as they mature. The source mentions that children over a certain age can often consent to their own medical treatment for specific things, like birth control or STD treatment, without needing parental consent. And if a child becomes legally emancipated before age 18, they gain adult rights and responsibilities, and crucially, the parent's duty to provide financial support ends.
Wow. We have genuinely done a deep dive here. We've gone from the definition of marriage all the way through ending relationships, dividing assets, supporting spouses and children, figuring out custody and visitation across state lines, the role of agreements, and how the state steps in with adoption, domestic violence protection, and children's rights.
It's a huge amount of ground covered in your source material. And it aligns with what the source itself flags as frequently tested areas: jurisdiction, UCC, JEA, WISA, modification of support and custody, and the validity of marital agreements. We hit all those hard.
And it also mentioned those unexpected issues, like paternity, adoption, grandparent rights, which we also managed to unpack based on the material provided.
Right. And hopefully breaking down the different state approaches, community property versus equitable distribution, the different child support models helps clarify things for you, especially if you're comparing rules or preparing for essays.
Absolutely. For anyone listening who needs that comprehensive understanding, really grasping these core concepts, best interests of the child, significant change in circumstances, marital versus non-marital property, the jurisdictional frameworks like UCC, JEA, and WISA, that's the foundation this deep dive aimed to build from your sources.
It's about understanding the specific rules, the definitions, the factors courts consider, and the procedures involved. That's the pathway to comprehension in a field like family law.
It truly is. It's a reminder of how law attempts to structure these deeply personal, often very messy human situations.
It does. Which leads to a good final thought.
Yeah, something for you, the listener, to chew on based on everything we've just unpacked from your sources. We've seen how family law uses defined rules, procedures, and standards, sometimes quite rigid ones, like the finality of property division or strict jurisdictional tests. Given the incredibly personal, emotional, and complex nature of family relationships, how well can this legal framework truly capture and address those human nuances? Or perhaps is it precisely this structured, sometimes impersonal, focus on standards like best interests or equitable distribution that ultimately serves society best in navigating these inherently difficult situations? Does the process itself, despite its challenges, help achieve the fairest outcomes possible?
It's a fundamental tension in family law, definitely worth reflecting on as you use this material. Thank you for bringing this critical and complex topic for us to dive into. We really hope this breakdown gives you the clarity and comprehensive understanding you were looking for.
Definitely revisit your source material now with this structure and these key concepts in mind. It should really help solidify how all these pieces fit together.
Absolutely. Good luck with it.
Until next time, keep diving deep.